Hello everyone, welcome to Apti Plus Academy for Civil Services. It's a video on daily news and editorial analysis, which I'll be covering from the Hindu and Indian Express. So the most important news and editorial that are relevant for the preparation of civil services examination will be discussed in this session. Let's get started with the news topic list. Today is 11th of January, the first important article. That is RBI revised guideline for the locker management. This is from the text and context page of the Hindu. Second, Defense Acquisition Council not to purchase indigenous defense system. Third, we won't pay a firing more, say the Union Carbide. This was a statement that was given before the Honorable Supreme Court. We'll see the detail, what are the issues. Fourth, Australia PM said to visit India to boost trade pact with India. And the last is an editorial barking up a wrong tree. This is with regard to the new voting system that is proposed by the Election Commission. Apart from the news and editorial discussion, at the end of this video, there will be MCQ based questions. These questions will be based on current affairs that will help you for the upcoming prelims examination. So without any further delay, let's get started. And before I begin this session, those of you who are new to our channel, do not forget to subscribe Apti Plus Academy for Civil Services on YouTube. If you like this video, if you find this video informative and helpful, do not forget to press a like button. So starting the session with the first news, that is RBI revised guideline for the locker management, something important for General Studies paper 2, that is the government policies and intervention in various sectors and issues arising from a design and implementation. And this particular topic might also be relevant for General Studies paper 3 as well, where Indian economy and issues pertaining to development is concerned. So in order to enhance the safety, transparency and effective management of the safe deposit of the lockers by the bank, the Reserve Bank of India has recently released a list of revised guidelines which come into force from 1st of January 2022. The guideline followed the observation made by the Supreme Court in the Amitabh Das Gupta versus Union of India in February 2021. So this was a ruling after which the Supreme Court has made the things more transparent, safety and more effective for the banking system. The agreement with the existing customer were to be renewed from January 1st, 2023. This is what the Supreme Court in its direction has noted, and this direction was given to all banking institutions in the country. And this is the image of the bank locker. How does the bank locker look like? I think most of you must be aware and have seen this locker. So to run a locker services, you have to apply in bank, and bank will charge you according to the duration for which you are availing the benefit, right? Although the Supreme Court ki recent ki guideline hai, where they have said that there would be an advance payment which will be rendered by the customer to the bank. Now, what was there in the Amitabh Das Gupta case? So he was basically a customer of Union Bank of India, and he alleged that his locker was broke illegally, citing an incorrect assertion that has not paid dues between 1993 and 1994. So bank ne aisa claim kiya. This was a false claim by the bank that he has not paid the amount, right? The locker's amount was not paid by him. Now the chief manager of the bank has admitted that incorrectly the part and process of the brokerage took place, and he apologized for the same. And Mr. Das Gupta went to collect his contents in the locker. He find that he has submitted 7 ornaments in the locker, but only 2 of them were in the seal. Other than that, the 5 of them were in the non-seal. So this created a sense of suspicion and a fraud from the bank end. Now in the verdict, the court has noted that impositions of liability upon a bank with respect to the contents of the locker is dependent upon the provisions and appreciation of the evidence in a civil suit for such purposes. तो सुप्रीम कोर्ट ने कैटेगोरिकली कहा है अगर किसी तरह की लॉसेस होती हैं कस्टमर को तो कस्टमर उसके लिए लॉ सूट फाइल कर सकता है, राइट? Now the Supreme Court eventually ordered that the lender to compensation, उन्होंने compensate करने की बात की, and even added that existing regulations in the locker management were inadequate and muddled with no uniformity rule. So this was with regards to the Amitabh Das Gupta case. Now, what changes for the banking system after the ruling that was there by the Supreme Court? क्या-क्या चीजें change हुई हैं, and what are the things that will proceed further? So now, while allocating any locker, the bank entity, right, banking की अगर बात करें, the bank has to enter into an agreement. एक agreement करनी होगी between the bank and the customer with a duly stamped paper, and the copy will be provided to both parties. So the copy of agreement will be there by the customer as well as by the bank, right? Now, in terms of contract, basically not, अगर बात करें in terms of contract, which must not be more onerous or required for an ordinary business, safeguard of the interest of the bank. So it should not be an onus to the bank, but definitely the bank will be liable to take care of all the belonging that is deposited. The provision entails that ensuring the safety of the locker and its management, rent collection and verification and transfer is revealing of the content. So the details of the rent, the things that is already kept in the locker has to be there in the agreement part. The bank would not allow to obtain the term deposit at the time of the allotment with the consumer. So now the banking system will call for an advance payment that has to be paid, right? तो अब सुप्रीम कोर्ट ने कहा है कि एडवांस में टर्म डिपॉजिट करनी होगी उन्हें उस अमाउंट की. Now it would cover 3 years and rent, and charges of bearing an open locker would be locker hindrance neither operating nor pay the rent. अगर किसी कारणवश rent नहीं पे की जाती, then bank has an obligation with the prior notice they can check up the locker. Now the central idea is to ensure that the prompt payment for locker rent should be there to the banking system. Now, in case of merger of a branch, what is going to be there? In case of any merger, closure or shifting of a branch, this would require the physical relocations of the lockers, and the bank would be required to give notice in 2 newspapers. तो सुप्रीम कोर्ट ने कैटेगोरिकली कहा है कि अगर किसी भी तरह की शिफ्टिंग हो रही है ब्रांच की, अगर वो एक जगह से दूसरी जगह पे शिफ्ट हो रही है, उसके लिए 2 न्यूज़पेपर में एडवर्टीजमेंट की जरूरत पड़ेगी. सो देयर नीड टू बी हैन एडवर्टीजमेंट इन 2 न्यूज़पेपर. और न्यूज़पेपर के अलावे जो कस्टमर है देयर ही नीड टू बी इन्फॉर्म 2 मंथ प्रायर, तो 2 मंथ प्रायर उसे इन्फॉर्म करने की भी जरूरत होगी. सो दिस इज हाउ द ड्यू प्रोसेस हैज बीन सेट बाय ऑनरेबल सुप्रीम कोर्ट, एंड दिस हैज टू बी फॉलोड बाय ईच एंड एवरी बैंक. फर्दर, द लॉकर रेंट इज कलेक्टेड इन एडवांस. Proportionate amount required to be refunded to the customer if he or she surrender the account, and the bank would not be under any liability to ensure content of the locker against any risk or whatsoever. Additionally, under no circumstances it can offer insurance product to its customer for ensuring in content. So the insurance provisions has also been taken care of. Now, what is new for the customer as such? For lockers operated through the electronic system, the bank must institute measures to safeguard it against any breach of security, and it must also devise a standard operating procedure, जिसे SOP भी कहते हैं, for issuing the new password to the customer who have forgotten their password and reset the password. So this is the process that has to be followed against the customer, and a due process will be there so that the reset of the password process has to be done from the bank. The customer must also inform the bank immediately that they have lost their key or any digital password. The bank should revise the discretions to basically बैंक के पास ये discretion होगी, बैंक रिजर्व करती है इस तरह के discretions to observe open the locker with regards to due process, and even the rented stand pending for 3 years in a row. अगर 3 साल तक अमाउंट पेड नहीं हुई है, देन बैंक के पास डिस्क्रिप्शन है कि वो प्रायर इंफॉर्मेशन दे करके बैंकिंग के लॉकर्स को चेक कर सकती है. दे मस्ट हाउएवर इन्फॉर्म द यूजर्स विद अ रीजनेबल अपॉर्चुनिटी विड्रॉइंग द डिपॉजिट ऑफ द कंटेंट्स, एंड द ब्रेक ओपन प्रोसेस वुड टेक प्लेस इन प्रेजेंस ऑफ बैंक ऑफिसर. एक बैंक ऑफिसर वहाँ पे होना चाहिए, राइट? देयर शुड बी अ बैंक ऑफिसर्स and 2 witness, right? A 2 independent witness is a part of the process that has to be there. So this is how the things will work. Without this, the bank people will not be allowed to follow it. And the idea to collect the evidence is in a case of dispute for any future. So this evidence will act as basically an evidence for a court of law if required for any purposes. Other news, that is Supreme Court not to purchase indigenous defense system, something important for General Studies paper 2 under the subtopic, that is the government policies, intervention and development for various sectors and issues arising from it, design and implementation. This is also important for General Studies paper 3 in the defense equipments, internal security purposes. Now, boosting India military preparedness, especially on the borders facing China, the Defense Acquisition Council, has headed by the Defense Minister, gave the go-ahead for the 3 proposal, and the total acquisition will be 4,276 crore rupees. And the final decision is to be taken by the Cabinet Committee on Security. So this is the apex body which finally decide on the approval process, and this is headed by the Prime Minister. और अगर बात करें Defense Acquisition Council की, this is headed by the Defense Minister. Now, what is a proposal for the approval? So the proposal approved for the Defense Acquisition Council include the helicopter Na, that is Helena, and anti-tank guided missile, जिसको ATGM भी कहते हैं, short range air surface defense system, BrahMos cruise missile, and fire control system for naval ship. All these 3 indigenous design and are part of the development project. This will be the entire process will be developed with indigenous capabilities and possibilities, where India is trying to explore more Indianization of the military. Now, these are some of the part that is being developed. This is a fire system, this is a BrahMos missile, and this is Helena. So 3 images to give you more clarity about the part that is being developed and procured for the defense forces. Now, about the Air Defense Acquisition Council, the Defense Acquisition Council, अगर बात करें DAC, जिसे Defense Acquisition Council भी कहते हैं, it's the highest decision making body, and this will decide upon the new policies, capital acquisitions for the 3 services, that is Army, Navy and Air Force, Indian Coast Guard as well. And it's apex body for approving the proposal for 3 services. The Defense Minister is the chairman of the council, and it was formed after the ministry recommended on reforming the national security in 2001 post Kargil War. So background of the Defense Acquisition Council is very important. Now, we won't pay far more. This is the Union Carbide has said in a statement to the Honorable Supreme Court, something important for General Studies paper 2, that is the welfare schemes for the vulnerable section of the population by the center and the state, and also important in the same paper, in General Studies paper 2, where the role and function of executive and judiciaries are concerned. So, rebuting the central government claim on an additional compensation with regards to the 1984 Bhopal gas tragedy in the Union Carbide Corporation, which is properly known as UCC, or Bhopal tragedy was a basically case that was known. So, Supreme Court में company ने, UCC ने ये कहा है that they are not going to pay any single amount, right? And they have already made a payment of $470 million. This was agreed upon both by the central government and the UCC, that is the Union Carbide Corporations. Now, the center in its curative play has contended that 1989 settlement is seriously imparted, and it sought an additional fund of 7,400 crore rupees from the pesticide company. So UCC was a pesticide company. They were basically making the pesticides, और इस पर्टिकुलर इंसिडेंट में मिथाइल आइसोसाइनेट जो गैस थी, जिसकी वजह से काफ़ी लोगों को काफ़ी ज़्यादा नुकसान हुआ. A lot more people have find that, and even the consequences still continues in the region. The government said that a fresh data on more suffering caused by the incident, and the government wanted that these compensation amount should be given. But यहाँ पे कुछ catch है जो आपको समझने की ज़रूरत है. Why government is coming with such long time and asking for the fund that is there? So, talking about the observations and argument that were given, the 5 bench of the Supreme Court has said that the government is walking a slippery slope by seeking a reopen of the settlement amount after 30 years. This is very true on the part of the Supreme Court, that why the central government is coming to Supreme Court after 30 years and asking that company to pay them. Why the settlement amount was not decided at that point of time. And even the Attorney General, in appearing on the behalf of the center, has said that the tragedy presented an extraordinary situation and government was looking to reopen the settlement but only wanted to act. So the center has said that they are not looking to add it. Basically कोई नई बातें करने की बात नहीं, उसमें amount को extra देने की बात की. But again, the Supreme Court has definitely were not inclined. Let's see what is going further, because these company will further be operating. They will be filing the other petitions in the Supreme Court as well. So this is how the Union Carbide UCC factories actually look like after the incident, right? And this was the world's worst industrial disaster. On the night of 3rd of December 1984, 1,000 people died and 30 tons of highly toxic methyl isocyanate gas was leaked from the Union Carbide factory, which is based in Bhopal, Madhya Pradesh. Now, Australian PM to set visit to India to boost the trade pact, something important for General Studies paper 2, that is bilateral regional grouping and agreement involving India and affecting India's interest. The Australian Prime Minister is set to arrive in India to strengthen the India-Australia economic cooperations and trade agreement, and India-Australia will carry out a discussion on varieties of issues like clean energy, tech, digital trade and procurements. Focus area की अगर बात करें, India-Australia economic cooperations and trade agreement will cover major important areas that include trade in goods, trade and services, rules of origin, technical barriers to trade, sanitary and phytosanitary, right, measures, some custom procedures to trade facilitations, trade remedies, legal and institutional issues, movement of natural persons. So these are the focus area upon which the discussion will take place between the Prime Minister of India and Australia. Now there's an economic cooperations and trade agreement. This is less than the comprehensive bilateral trade pact, which was signed on April 22 by the Union Commerce Law Minister and his Australian counterpart. Apart from this the economic cooperations and trade agreement, Australia has also entered into a free trade agreement with United Kingdom last year only. So talking about the other value in terms of India's trade, so the trade worth of export is $6.9 billion and import is 15.1. So other parts are also there. Services की अगर बात करें, 4-year visa for 18 chef, yoga teachers every year, post-student workers for Indian student reciprocal, multiple entries and holiday for visa for 1,000 young Indians. So और अगर immediate benefits की बात करें, duty nil for 85% of Australian exports, nor although duty is like 30.3% of tariff, limited quotas on orange, marinds, almond, pears and cottons. Now, moving to the editorial of the day, barking up the wrong tree, something important for General Studies paper 2, that is the government policies and intervention for the development of various sectors and issues arising from a design and implementations. So what are the issues that I'll be discussing in this editorial? Before we look into the issue part, just have a direct look at the theme, that is the Election Commission's remote electronic voting machines. Some of the issues include the background, the concern and queries, example from other countries, and the conclusion part. So to encourage domestic migrants to exercise their franchisee, जो इलेक्शन कमीशन ऑफ इंडिया उन्होंने कोशिश की है कि माइग्रेंट वर्कर की पार्टिसिपेशंस को बढ़ाई जाए, उसके लिए एक नई प्रोटोटाइप स्टार्ट की गई है. दिस प्रोटोटाइप इज नोन एज the multi-constituency remote electronic voting machine, which would enable the migrant worker to vote from the polling station, for a remote polling station. And the commission has announced that it will demonstrate the prototype to the representation of all political parties on January 16, 2023. The Election Commission has said that its inability to vote due to internal migrations of the domestic worker is one of the prominent behind एक ऐसी कारण है जिसकी वजह से लो वोटर्स टर्नआउट देखी गई है इवन द जनरल असेंबली इलेक्शंस. Now what is the machine actually and how it will work? So talking about the electronic voting machine, this is something that will work. The remote voters must register online and offline for a pre-notified time. After successful verification, they will be providing with the facilities of a slip. And this EVM will just work as an RPM single ballot unit that can cater many constituencies in the polling station using a dynamic ballot display. But again, there's other loopholes that has been discussed in this editorial, some challenges that pertain to the implementation of this. Some concern and queries that has been highlighted in this editorial. So first is, how would it ensure that those who wish to apply in the remote voting can do so without any hindrance? And this can only be done with the verifiable zero trust technology that is critically linked to digitalization of electoral roll, which itself require a thorough examination. Second issue जो है, that is interested with all person allowed to vote remotely invalidated for local voting, and also nobody is incorrectly invalidated. Since still the different locations correctness will not be easy to demonstrate in the public verifiable way. Third, how will the voters, both electronic and other VVPAT slip consolidated, will be counted? With counting and VVPAT audit happens, the remote locations at the home constituencies after the consideration will be the part. If VVPAT audit happen, then how will it interest a verifiable consolidated that happen correctly? So there are a lot more verification process that is concerning for an individual who is contesting an election, or basically is actually voting that part, right? Fourth, will all have a polling agents to the remote locations and will ensure that the different political environment and some side of the remote voters will also be covered. एग्जाम्पल्स की अगर बात करें, कुछ ग्लोबल एग्जाम्पल के तौर पे, द रिक्वायरमेंट फॉर द पब्लिक verifiable elections, the Germany Constitutional Court has pronounced that EVM in 2009 and has exerted an honorary nod to the Germany, but also many other jurisdictions of Europe and America and Pakistan is following the part. It has also led the US National Academy of Science to recommend against the pure electronic voting in a public report order of 2018. Now, to conclude that part, definitely there are a lot of challenges and there are a lot of constitutional and consensus that has to be there from the political parties. तो ज़रूरी है कि जो existing law है उसमें कुछ amendment की जाए, और ये जो changes होंगे, gadgetic changes होंगे, that will require the political consensus, representation of people act, the conduct of elections rules जो है, and even registrations for electoral rules will have to be amended, and remote voting is then only possible. Now, while using the demonstrations, the essential of public accessibility and their acceptability is very important to ensure the safety and security. And सिर्फ mere computer और digital security पे इस तरह की demonstration क्या practical में इतनी ज़्यादा basically वाइवल होगी क्या, इसके results उतनी ज़्यादा होंगे, ये तो tested होगी, due process of time will tell. So it's a rigorous process that can only be articulated, that can only be practically viable once it is conducted. The demonstration process will not tell you the entire thing, right? So this is how the things need to be taken care before the implementation part of the process. Now, moving to the MCQ questions of the day. Before I proceed, just to tell you the answers of yesterday's questions. For first question, the correct option is C. For second question, also the correct option is C. Today's MCQ for practice को बताना है, which of the following has released the COVID-19 performance index? Harvard University, Serum Institute of India, Lowy Institute, World Health Organization. The second question is regarding the 4th edition of Future Investment Initiative was hosted in which of the following city? Sweden, Laos, Riyadh, or New Delhi. So do check it out for the correct option. This type of question will definitely give you a base, although a direct question cannot be expected on this line, but it will give you a base and background how things are working in terms of question. So practice a lot more question, that will give you an edge over the upcoming prelims examination. This was all about for the daily news and editorial analysis, followed by the MCQ questions. If you have any other concern, do let me know. I'll be more than happy to assist you. For time being, I'm signing off. Thank you so much for watching this video.